Hello, everyone. We are live. Welcome to Legal Bites. And if you're new here, my name is Alita. I am a lawyer licensed in California and DC. And on this channel, we explain the law one bite at a time. So before we get started, I have two guests with me, two great guests that I'm really excited to have on here. I have Darth Crypto and I have Andrew Branca. Sorry, Jesse Feinberg, also known as Darth Crypto. But that's how most of us know of him on Twitter. But anyway, so before we get started, I just wanted to do a quick few sort of housekeeping matters. But as we're watching this, if you guys are enjoying it, be sure to like the video, share it, subscribe to the channel if you are enjoying it that much. And if you are especially enjoying it, please note that we cover all kinds of topics here. We really don't shy away from controversy. So the majority of our live streams actually get demonetized pretty early on into the live stream. So if you really want to support us, there are several ways of doing that. The links are all in the description below. So with that, I will bring on my two guests. So
Hey.
Hello, how are you guys doing?
Awesome, living the dream, except for the overflowing bathtub in my house a few days ago. But other than that, we're doing fine.
Except for the 3 sick toddlers, sick wife, and sick me. Doing great.
Oh man, oh no. I guess it's that season, right? When everything starts to go wrong all at the same time.
We also the kids don't have immune systems after being locked inside for 2 years, so that doesn't help either.
That too. So let's do some quick introductions in case there's anyone who is watching this that has not already met you guys. Andrew, we'll start with you.
Sure. I'm Andrew Branca with Law of Self-Defense. You see my little URL there on the screen if you're watching this in video. I'm an attorney who does use of force law. That's all I do. I don't have a generalized criminal defense practice. I just do self-defense, defense of others, defense of property cases. Now, this year is my 30th year doing that. So I've been at it for a little bit, and an overnight success, as I tell my wife. And so generally that's what I do. I comment on these cases. I do legal consulting for other attorneys whose clients have been involved in a use of force event. And we do a lot of education and training of people so they know where the legal boundaries are, so they don't overstep them through simple ignorance and then find themselves looking at a long jail term.
Absolutely. All right, Jesse.
So my real name's Jesse Feinberg. I go by Darth Crypto on social media because I used to be purely a cryptocurrency day trader. And then with the Rittenhouse case, all of my various skill sets kind of came together. I've worked as a legal researcher, paralegal for my parents who were litigators. Actually started going to law school at Arizona State, and then I decided it just wasn't for me. But I really love the law, so I got into discussing these topics, and my work actually directly helped the Rittenhouse defense. I emailed Mark Richards directly, and it was a pretty amazing experience. Since then, people have been clamoring for my view on these things, so I've just jumped right into it, and I've made some new friends along the way, and lots of lawyers to prove me wrong and boost my ego when I'm in fact right. I did change my Twitter bio to identify as a lawyer, so if you don't refer to me as a lawyer, despite my lack of a JD, you are a bigot, because I am translegal.
Well, although just be a little bit careful about that, because you want to make sure that people understand that you are not actually a lawyer and you're not putting yourself out there. That's one.
I thought they got the joke.
As long as people understand that. Because I mean, never underestimate the power of somebody who doesn't understand a joke.
And if you want to find me on Twitter, I'm DEFNOT Darth. So Def Not Darth. You can just Google Darth Crypto. You'll find me. And on YouTube, it's Darth Crypto spelled exactly as you see on screen.
Okay. Oh, so I didn't realize you were also on YouTube as well. So I will have to add the link to your YouTube channel in the description below.
YouTube.com/Darth Crypto.
Okay. Otherwise, I have your both of your links to I think Twitter and YouTube. I have at least Andrew's YouTube, and I've got Andrew's website also linked in the description below for anybody that wants to go and check you guys out more so. So yeah, this is one of the beautiful benefits of having been part of that. I like to call it the Rekieta Law Stream of Wonder from the Kyle Rittenhouse trial, was getting to meet both of you, because it was obviously a really crazy experience, and meeting both of you was a really great thing, because as Jesse said, he was able to actually directly help the the defense with their position and putting on their case in the trial. And Andrew, of course, is one of the leading self-defense law experts in the country. So I'm very, very happy to have both of you here. So I know that there's a lot of interest in the Chad Reed shooting incident. It's like a lot of people have been talking about on Twitter for a long time. We talked about it backstage before we got started. So if there is time afterwards, we are more than happy to get into it to talk about that case. But beforehand, really the focus of this video that we want to do first is to talk about Kyle's Law and Kyle's Pledge, since both of you have sort of put that those proposed laws forward, and so I want to hear about that and kind of see some of the overlap and some of the differences and kind of what moving forward you guys are looking forward to going on ahead. So Andrew, why don't we start with yours, since yours is kind of the center of the concentric circle with the two propositions.
Actually, if you don't mind, Andrew, I could give some quick background about how the two differentiation is. So what happened was, immediately after Kyle was acquitted, I did a video which went viral and listed what I was calling Kyle's Law. So I had a hashtag that was blowing up and starting to trend. And then I was listing several different things I'd like to see in an overall package of some form of legislation. And then as I was doing that, Andrew was simultaneously working on his video where he discusses Kyle's Law. So he inadvertently hijacked that hashtag. And then I was excited to have him do that because I love his idea. So I DM'd him and said, the Kyle's Law hashtag, let's refer to your specific legislative proposal as Kyle's Law, and I'm going to change what I'm proposing to Kyle's Pledge, which is a list of various things, and his Kyle's Law idea is actually one of the specific portions of that list that I've come up with that I've now called Kyle's Pledge.
Yeah, exactly. So yeah, that's sort of how I started to see it. Also, was I actually thought that both of you guys were working together on it until you kind of explained to me through Twitter DMs like the background of it. So actually, well then in that case, Jesse, why don't you kind of list off the stuff outside of the Kyle's Law that you were proposing in your Kyle's Pledge, and I can pull up your tweets about it.
Okay.
If that's helpful.
Or you can pull up my screen if you want, if that's easier.
Oh yeah, let's do it. Let's share your screen.
Okay, so this is the entire thread, which started with me, Kyle's Law. That's when I was trying to get that to trend. I gave some examples, things that would never happen if we had Kyle's Law. But then the ultimate list, as I sort of shifted towards the whole pledge thing, I did a video essentially saying, we need all of our politicians to back this. You're not going to get my vote if you don't support these proposals. So one of which is banning or in some way mitigating political prosecutions, empowering citizens if local governments abdicate their duties. So for instance, in Kenosha, the citizens of Kenosha, some were beaten half to death. Some had their entire livelihoods burned in front of them. There was no fire department and no police department to protect them. Their only recourse was to arm themselves or to ask other people to arm themselves to assist them in protecting their livelihood or their lives. So when a local government abdicates their duty to the tax-paying citizenry, we need some sort of recourse, whether they become financially liable for 100% of damages, even ignoring any insurance, they are 100% liable. Or maybe in situations like that, there could be some sort of emergency change where use of force law maybe changes, something like that. There's various things we could discuss to get there, but that's a big part of it. Fixing libel laws and stopping the media's politically based defamation and jury pool tampering, as we've all seen happen with Rittenhouse, considering 50% of the country thinks he crossed state lines with an automatic bazooka to execute, black protesters. We've seen that in action, unfortunately. And I think Times v. Sullivan drastically needs to be revisited, dramatically so, because we need to do something about libel in those cases. And then standardized self-defense law. And this is really where Kyle's Law came into play. This is specifically Andrew's area of expertise, and the law he's proposing would go a long way in helping both banning political prosecutions and creating some sort of standard for self-defense law and the recourse potential defendants have should they be the victim of prosecutorial misconduct or a malicious prosecution.
All right. So I guess with that, why don't we go into Kyle's law, the specifics of that, since you mentioned it. Andrew, we can talk about your
Sure.
sort of what that piece that would encompass that
I mean,
that Jesse is sort of envisioning as part of his whole thing, but you kind of are just focusing on that.
right. So everything that Jesse just pointed out is they're all reforms that would do well for the public and self-defenders in particular, especially in riotous conditions. I would support every one of those initiatives. My own concern is a bit more focused, and that is I frequently see these cases brought to trial, self-defense cases brought to trial, where there's literally zero evidence inconsistent with self-defense. In a case where the state knows ultimately they'll be obliged to disprove self-defense beyond a reasonable doubt. And if you have a normal, traditional prosecutor, and he looked at an investigative report where there was essentially zero evidence inconsistent with self-defense, he would never bring that case to trial because he knows he can't win it ultimately. But the cases get brought to trial for other reasons than legal merit, for politics, for pressure, for political capital, for the prosecutor's own prestige, to assuage riots in the community, whatever the case may be. But none of those are, to my mind, legitimate reasons for bringing these cases to trial. And I see scores of them. I mean, we start all the way back with George Zimmerman. Now we have the Kyle Rittenhouse case. There's many cases in between. And so it troubles me that these defendants can be dragged into the cost and peril of a trial on the whim of a prosecutor. And for folks to understand, the cost can easily be in the hundreds of thousands of dollars. And the peril, there's never a 0% risk of conviction. If you're put in front of a jury, there's some percentage chance you'll get convicted no matter how innocent you are. Innocent people do get convicted. And we shouldn't put someone to that cost and to that peril without good reason on the legal merits. And too often I see in these cases, there is no legal merit to the prosecution and the person's dragged in anyway. There should be either a real threshold that has to be met before a person can be dragged into court. And we're supposed to have a probable cause threshold. Unfortunately, it's pretty much a rubber stamp these days. Or if we're not going to have the threshold going in, then we need some consequences for the prosecutor coming out, when at the end of the trial, we can clearly see that there was no legitimate basis for bringing this case in the first place.
Right. So you talked about on your website, you talked about how there are sort of different percentages that you're sort of envisioning of, and these are, I think, a little bit more loose, just sort of for explanatory purposes, right? For percentages of degrees to which the prosecution has sort of proven their case, right? Beyond, if they've actually proven it beyond a reasonable doubt, that would be about 90%, right? And so you
Sure.
talked about that if it gets as low as 50%, that's sort of where your law sort of comes in. Is that accurate?
Yes. So we have to set a threshold someplace. And I think, in theory, a probable cause hearing, for example, is supposed to ask the question, well, is it at least more probable than not that this crime has been committed by this defendant, whatever charge we're bringing against him? If not, we ought not be dragging that person into court. But unfortunately, probable cause hearings are nonsense in America today. It's basically just assume that everything the prosecution is saying is true, that there's no consideration of what the counter argument from the defense is. And anytime you only listen to one side of an argument, obviously that side sounds compelling, and the defendant ends up dragged into court. There is no genuine threshold that a prosecutor has to meet. Same with the grand jury process. They really only hear the prosecutor's side of the story. There is no defense. And if a grand jury only hears one side of the story, of course they return an indictment. It's like, I believe Alan Dershowitz was who said you can indict a ham sandwich in America. And it's true, because if you only hear one side of a story, it always sounds compelling. So there's no real threshold that a prosecutor has to meet before going into a trial. Frankly, if we just did that, we wouldn't need most of the rest of this, because at least in the very focused problem I'm concerned about, which is dragging people into court on a whim of a prosecutor. If we had genuine probable cause hearings, that would be much less of an issue. Because we don't have that, my proposal in Kyle's law was to hold the prosecutors accountable for when they bring a case to trial that they know ultimately they'll have to prove beyond a reasonable doubt. and they don't even have 51% of the evidence, much less 90% of the evidence.
Right.
Yeah, I have an idea that builds upon what Andrew's doing, but this might actually be a good question for you because it encompasses what you're already discussing, but brings in another example. I was explaining this to my father, who's an attorney as well, as I mentioned, and he understood what I was getting at, because in the Darren Wilson case, you had two local prosecutors, you had the federal DOJ, all say that it was 100% clean shoot. Since then, they've elected two new district attorneys, both of which, in order to get elected, had promised that if they're put in office, they will prosecute Darren Wilson. So you now have a situation where the people want someone's head on a pike, and they're going to elect whoever says they're going to do it. And Darren Wilson has to sit there and wonder if one day they're going to get somebody in office who's going to prosecute him unjustly.
Well, they keep doing that. They keep electing new prosecutors who run for the office on, as you say, on the talking point that they'll reopen the Michael Brown, Darren Wilson case. And they get in office, they get elected because generally they have George Soros money behind them. So they bring $500,000 to a prosecutor's race that normally might involve $5,000. So they just buy the seat essentially. But all of them, when they reopen the case, they look at the facts and then they close it again a few weeks later because there is no legal merit there. So I don't really see anything happening there. But the Darren Wilson case is a very good illustrative example. So that prosecutor who was involved in that case, he'd been the prosecutor in that jurisdiction forever. For I think it was 30 years, maybe more. And when he brought that case to the grand jury, he did something he was not obliged to do. He told the grand jury both sides of the story, not just the prosecution side, but the defense side as well. And when the grand jury heard both sides of the story, they returned a no true bill. There was no indictment. There was no trial as a result. That guy got targeted by Soros-funded sources, and he got replaced by a young prosecutor running on the campaign talking point of reopening the Darren Wilson case. So that prosecutor who'd been in that office for decades, he did the right thing. And the consequence for him was he lost his job. He lost his career, and a new person took over. So that's a lesson to every other prosecutor out there. You can do the right thing if you want, but don't expect to keep your job afterwards. And now we have this prosecutor down in Georgia around the Ahmaud Arbery case who had recused herself from the case, and now she's facing felony charges of failure to do her duty because she simply decided she didn't stop the case from happening. She just said, I'm not the right person to prosecute this case. So it was handed to a different prosecutor. Obviously, the trial was still pursued. Nothing was stopped. And she's looking at a felony conviction now. And even if they don't get that, it's a lesson to every other prosecutor out there. You better bend the knee to the mob, or at the very least, you'll lose your job, and maybe we'll put you in jail.
Yeah, I think grand jury reform is something that needs to be part of this as well. Because as you mentioned, the Dershowitz quote, you can indict a ham sandwich, you can with a grand jury. And that's the big issue. If the defense had some rights in submitting a case to a grand jury, then a lot of these situations would never come to fruition, just like in the example you provided.
And often, in many jurisdictions, they don't have to go to a grand jury. I mean, in the George Zimmerman case, for example, they use what's called an information, which is a sworn document, usually sworn by a law enforcement officer, like a criminal complaint, attesting to certain facts in the case. And I see this over and over again, where you look at the criminal complaint or you look at the information, and there'll always be something extravagant in there to act as an accelerant, gasoline on the fire, to compel a prosecution. In the George Zimmerman case, it was that he racially profiled Trayvon Martin. Well, that sounds horrible, but they needed something to justify a second-degree malice murder charge, which is what they brought against him. So where was the malice? It was the racial profiling. Except when they actually get to trial, you never hear a word about racial profiling because there's no evidence of racial profiling. And once you get to court, you start making claims, they have to be backed up by actual evidence. So they made this up to put in the criminal complaint, to drag him into trial. And then when they get to trial, the claim doesn't exist anymore. And that's horrible and should not be permitted. And it happens in many of these cases. You look at the criminal complaint, same thing. You look at the criminal complaint, they're making claims in there that in hindsight will prove to have been completely fabricated, and no one is ever held accountable for that. It's like if you went to the doctor with a sniffle and the doctor said, you know what? There's like a 1 in a million chance you actually have cancer. So we're going to start you on chemotherapy and radiation right now because you came in with a sniffle. There need to be checks in between those two extremes before you're subject to that kind of therapy And that
And
should apply in the same context as a criminal trial as well.
And I think part of that is probably coming from the very American idea that we want to have a very open litigation practice, I guess, is one way to put it. You know, for example, like a very, very low pleading standard for any civil case. And so they probably, I would argue that a similar sort of standard applies to criminal cases through the low standard for probable cause hearings. I don't know if you would put that connection together, or if you would say that there's other reasoning behind it, or a different sort of history behind it.
I think it's largely an artifact of just the way the criminal justice system works for the criminal justice system. I mean, like any government bureaucracy, it mostly exists for itself and serves its own interest. 99.9% of the people who are put through that system are probably criminals. I mean, that's been my experience. It's relatively rare for genuinely innocent people to be subject to the criminal justice process. So if the system believes it's largely dealing with criminals, it doesn't care much about what the threshold is, because if they held a hard standard, if they held a genuine probable cause hearing for every defendant, they'd probably meet the standard, but it would be enormously time consuming. So the system is basically saying, well, it's not worth the effort. We know there's probable cause. This guy's a dirtbag. So we're going to kind of rubber stamp it and get them through the system, because otherwise we would be here all day. You know, when they have these hearings, a single court might go through scores of these hearings in a day. They take minutes each. Whereas if you had a genuine probable cause hearing, it would almost be a mini trial, hearing both sides argue out the point. It would take a day. You see this sometimes in these in states that have self-defense immunity laws, and they have a self-defense immunity hearing that you can demand pre-trial. And basically you argue self-defense before you actually get to a trial in this pre-trial hearing. I think those laws are great. But sometimes those self-defense immunity hearings take a week. I mean, it really is a mini. Folks, most murder trials take like 2 days. So the ones we see in the news are aberrations. That's not normal for even a murder trial to take 2 weeks, 3 weeks. That's extremely unusual. So when most murder trials take 2 days, and then you contemplate, well, a self-defense immunity hearing, which is really a probable cause hearing, what a probable cause hearing should be. You're asking the defendant to, or either side, depending on where the burden is, but to show self-defense by a preponderance of the evidence, by a probability. And if that can take a week, imagine what doing that for every criminal defendant would do to the system. It would completely clog it up. But to my mind, that's not an excuse. We're talking about individual liberty. I'm not willing to sacrifice individual liberty of any defendant, even someone who's probably a criminal, just for purposes of the efficiency of the system. I think that's where things are broken. And I think if the system wants to have a rubber stamp process, well, okay, maybe there's nothing I can do about that. But if they're doing it to someone who turns out later to have been innocent, they ought to be held accountable.
I have a good question for you, Andrew. So if you recall, one of the things on my pledge, which I'm going to push to get every politician to adopt, was standardization of self-defense laws. Is there a municipality, a state, anywhere in the country where you would say has the best self-defense laws that you would say that would be perfect to standardize nationally? Is there an ideal that you can identify that we could strive for, that I could put in writing and provide to people? Because I've already had state senators reach out to me because they actually saw my post once it started to go a bit viral. And I'd love to be able to give them that as an example. Is there anything that you would say in this country is the model that we should aspire to nationally?
The truth is, self-defense law across the 50 states is largely the same. The fundamental principles are the same. Of course, they all have their own statutes and case law and jury instructions, but self-defense law is very old law, folks. I mean, it's as old as human civilization. It goes back to the ancient Greeks and Romans for sure. In America, it came from Old English common law. It doesn't vary very much in the American states. The biggest variance is there's 11 states that impose a legal duty to retreat before you can use deadly force to defend yourself. 39 states don't do that. That's really the biggest variance. So it's not the black letter of the law that differs so much. It is how it's applied that can differ a great deal between a California and an Oklahoma and a Texas and a Massachusetts. And that's all part of that prosecutorial decision-making. And when they're not held accountable for loosey-goosey decisions and just dragging people into court on a whim, that's when we see these cases happen. But the self-defense law of Massachusetts, for example, is not much different than the self-defense law of Texas. On the margins, it's a little different. I mean, you'll see differences other than stand your ground. You'll see differences in self-defense immunity laws, or you'll see differences Defense of property varies a lot among the states. So when I say self-defense, I mean defense of persons, defense of yourself or defense of others. Very, very stable. Defense of property, defense of dwelling, defense of personal property. We see more variance there among the states, like whether, for example, Texas has this legal presumption of a reasonable fear of deadly force harm from an intruder who's forcibly, unlawfully entered your dwelling. We see that coming up in a lot of these Chad Reed discussions. Not every state has that. About half of the states have that kind of legal presumption. But there's not one state that has exceptionally good self-defense law compared to the others. The question is, how is it being applied? How is prosecutorial discretion being used? And unfortunately, if there's no check on that, when you have that discretion in the hands of an old school traditional prosecutor who does things in the old way, it's not been a problem. So everyone's been very comfortable with it. But when you put that discretion in the hands of someone who's explicitly politically motivated, well, then you get politically motivated prosecutorial decisions. And it's havoc, as they might have said in the
I'm thinking in terms of
Rittenhouse case.
castle doctrine in the way it's literally meant, not the way it's incorrectly applied, as you mentioned in one of your videos, but and stand your ground. Like in Massachusetts, you clarified it a bit, but from everything I was told, as an avid gun owner in Massachusetts, if someone breaks into my house, I have a duty to retreat unless there's an immediate threat to my life, even within my house with my kids 5 feet behind me. So that's the sort of thing. If there was, although you can't standardize that nationally because it would be a 10th Amendment issue, but there has to be some way to do that. Just to give you an example on my.
So that's how things can get altered on the margins. So the principle of the Castle Doctrine, meaning if you would have had a legal duty to retreat out in the public street, you're relieved of that legal duty to retreat if you're in your home. Every state has that in that generalized sense. But some states then begin to constrain it on the margins. So for example, Massachusetts will say, well, and most other states will count, for Castle Doctrine purposes, will count not just inside the four walls of your home, but also the curtilage, the area immediately around your home. Massachusetts says, well, we're not going to count curtilage. So if you have 1 foot outside your front door, we reimpose that legal duty to retreat. You don't have Castle Doctrine privileges anymore. Then Massachusetts will say, well, Castle Doctrine, we say you don't have to retreat in your home, period. But we're going to say that you reacquire that duty to retreat if the person you're fighting with, it's also their castle. So they're a co-dweller. So they're a spouse or they're an apartment mate. If that's who you're defending yourself against, you reacquire the duty to retreat. We don't give you Castle Doctrine privileges. So the general principle still applies. If it's a genuine intruder who broke into your home, you still have Castle Doctrine privileges in Massachusetts, but they constrain it on the margins because they don't like the law. The courts in Massachusetts don't like the legislator passed it over I'll call them the Supreme Court. They use a different term in Massachusetts, but the legislator, the Massachusetts Supreme Court basically said there is no Castle Doctrine. And the legislature, there was a public furor over this. The legislature passed a Castle Doctrine statute, one of the only, maybe the only self-defense statute in Massachusetts. Massachusetts has not codified self-defense. It's all case law. But the legislator passed this over the Supreme Court's objection. And so every opportunity they have, the court has, they constrain Castle Doctrine in the ways I just described.
One of the other aspects that you have in Texas with the presumption, especially in highly defensible property, if somebody's in my house, I cannot assume their intent unless they literally are charging at me with a weapon. I can't shoot them in the four walls of my own house. Just being in my house does not represent an imminent deadly threat as it does in other. Right.
So of course, what everyone's concerned about in those circumstances is there are cases where we have what might be called innocent intruders, people who are in the wrong place by accident and without malice. This can happen if a repairman is sent to the wrong address, if someone's visiting from out of town and you live, there's times I've lived in an apartment complex where every apartment basically looks the same. And it's, we had this case in Texas, the Amber Geiger case with Botham Jean, where she walks into the wrong apartment, shoots him dead. Of course, she was convicted now of murder, although sentenced more like a manslaughter case. And it turned out that the defense did investigations there. In that apartment complex, something like 30% of the residents had an innocent intruder walk into their apartment, or they had done it themselves, walked into the wrong apartment. So it's remarkably common. And the legislators and the courts don't want to issue like a 007 license to kill anytime you come across somebody who's in the wrong place. They want to see more than that before you can use deadly force. So even in the Texas, where they create this legal presumption of a reasonable fear, if someone's in your home, they have to be there not just unlawfully, but also forcibly. because if they used force to do it, then they can't be an innocent intruder, right? There might be an innocent explanation for someone, why someone opened up an unlocked door and stepped in. Maybe they're a repairman sent to the wrong address, or they're a guest from out of town who walked into the same wrong place. But if they broke something or they used force otherwise to get in, well, then there's no innocent explanation for that.
Right. So then I guess the question for you, Jesse, is how you would want to standardize the laws across all 50 states with all of these different exceptions in different ways. I mean, I would guess that you would probably want to strengthen self-defense law overall across the board in these various jurisdictions, but I wouldn't want to put words in your mouth.
Well, it's also
so what would you envision?
A lot of it is removing confusion and uncertainty. People don't know what they're allowed to do. It's you genuinely have to spend hours reading case law to know when I'm allowed to protect my family in my own home, and that's absurd.
And the thing about that is case law is always developing too. So that's it can change over time also.
Well, as Andrew said, it's all in the courts here. It's not codified in the legislature. So I don't know if it presents you guys would have to tell me if there's a 10th Amendment issue. Could you standardize some sort of self-defense law nationally? Is that possible? Or
I mean, what typically happens in these cases where there's an effort to try to standardize things, and we saw this with stand your ground laws. So I forget the name of the organization now, but there's basically a legislative proponent organization that had committee meetings and drafted a model stand your ground statute. And then they went from state to state. They found a legislator who was in favor of it in that state, who would propose it as a bill, and it would get debated and argued and adopted in that state. And that effort's been remarkably successful. People mistakenly think that, for example, this is how they did it in Florida when Florida became a stand your ground state. Many people mistakenly think that Florida was the first stand your ground state, which is really bizarre because about half the stand your ground states are stand your ground by case law. California is a stand your ground state. It's in the jury instruction in every self-defense case. There is no legal duty to retreat, but there is no stand your ground statute in California. It doesn't exist. It's all case law dating back to the 1800s under California law. So when you see these news articles that say, oh, there's 17 states that are stand your ground states, what that journalist has done is looked at statutory language in each of the states and found 17 states with a stand your ground statute. That's not the number of stand your ground states. The number of stand your ground states is roughly double that, 39 states. So if we want to standardize things, the best way to do it would be something like that stand your ground process, where you have somebody who's drafts model legislation, walks it around to the different states, and finds someone who's willing to advocate it within that state. If you look at that, for example, the stand your ground, about 15 states in the last 20 years have adopted the stand your ground statutory language, and the language is all the same in every one because it's based on this model statute. And that's what we would want to do with something like Kyle's law. We would come up with some model statutory language and walk that proposal specifically around to the different states. Find somebody like this gentleman in Oklahoma. I forget his name, but someone's brought him to my attention. A legislator there is proposing a Kyle's law. I don't know if he came up with it independently, like you and I did, Jesse, or if he saw something we were doing and decided it was a good idea. And I can't find a copy of any actual proposed bill.
He sent it to me, and he pasted it on my threads days after I posted it. So
well, if you could forward it to me, I'd appreciate that. I'd like to see it. But I want to make clear to folks, I'm just a small town lawyer. I'm not a politician. I'm not looking for credit for any of this. I just want to see what I see as a broken part of the system fixed. And if a politician is willing to run for that and it's good for them, awesome. I'll cheerlead them all the way. This is not Andrew Branca's law. This is whatever it needs to be named in order to fix the problem I see in the system.
Well, I think Kyle was the perfect catalyst, because I feel like what he's had to go through over the last year, in my view, to use his suffering for something good. I mean, everything that I listed, even the subjugation of duties to the local citizenry by the local government, when they say to the fire department and police department, don't interfere with these protests, which are clearly demonstrably riots. Everything I thought of sort of relates back to that case. But then actually on this thread, this is interesting. I gave a few examples of the overall suite of legislative changes that I would like to see. Some examples where you wouldn't, or where you wouldn't necessarily be seeing them now. I listed a few, because you had Jacob Chansley, the crazy guy at the 1/6 Capitol riot, dressed up like a Viking. The Viking shaman guy gets 41 months in prison when he didn't do a single violent thing. He got the same sentence as a protester who beat a Capitol police officer in the face. Just because he was the face and his picture of him dressed like a crazy guy went viral, he gets 41 months in prison, which is absolutely astounding. That's obviously politically driven. So the idea of reducing or mitigating political prosecutions would apply to a case like that. Another example, where if you had Kyle's law, the 70-year-old man whose jaw was shattered in Kenosha, who was trying to protect a mattress store, wouldn't have gotten beaten half to death. Or if he was, he would have some recourse because the local government abdicated their duties to protect him and the property where he worked that he was trying to stop from burning because the fire department couldn't come in. They weren't allowed to. So each one of the examples in my list, I could point directly to a story. And then I have two stories here, which directly relate to what Andrew's talked about. With Kyle's law, the media and politicians would face repercussions for lying and tainting the jury pool in the George Zimmerman case. When the media edited 911 tapes or changed photos to make Zimmerman appear white or to stoke racial divide, they would have to pay for that. And that comes back to revisiting Sullivan, because I still cannot stand that decision. I think it's insane that the media is in a position to start talking about you, which makes you become a public figure, and now they can defame you as much as they want, and you have no recourse without direct proof of malice. I think that's insane. I think Times v. Zimmerman needs to be revisited, and I think that's part of it. And another example I mentioned that Andrew's probably familiar with is Jake Gardner. Do you remember the Jake Gardner case? He was at a protest. This was after... Here, there's Pedro Gonzalez that posted about it. Jake Gardner was I forgot where they were. It was in St. Louis. He was attacked outside of his bar, and the Black Lives Matter protesters started rioting after the normal protesters left, and they attacked him. And he had no choice. He fired in self-defense and killed the guy. The prosecutor said, "We're not going to prosecute him. Everything was fine." The judge
this
said,
is the guy who killed himself?
Yep.
Yeah.
And then another prosecutor is brought in with the sole direction of, you better do what you're told and send this guy to prison to satisfy the mob on Twitter. And they prosecuted him, and he ended up dead. And this is a veteran who ended up dying after sacrificing, a portion of his life to serving this country, after a judge and a prosecutor had already said it was clearly self-defense. And
the only thing I would caution is I think it's a bad idea to put all these reforms, each of which I think has tremendous individual merit. If you put them all in one bill, you'll never get that bill passed.
Well, that's why
each of those reforms, even if you proposed one of them in isolation and you had 10% resistance to that, when you put 10 of them in one bill, you get 10% resistance to each point, and you get 100% resistance to the bill overall. So you really have to focus on each individually. That's why the stand your ground legislation was so powerful. It had one specific point, this issue of a duty to retreat, and they were effective in getting that. But if they had loaded it up with a bunch of other stuff simultaneously, you end up encountering what I call the laundry list form of argument, where someone will have, well, I've got 10 reasons why I don't like your thing, and they do number one, and you explain it away. You have a good counter argument. You do number two, and you have a good counter argument. You work your way all the way down the list to 10, and now you've countered every single point they make. And do you think they're convinced? No, they circle right back to number one, as if you'd never discussed it before. And then you can't get anything done. So you really have to have this. If we're going to take the model legislation approach, it has to be extremely focused. So you limit the amount of pushback that you get on it.
Well, that's why that's hence the adjustment. So the pledge is just a platform.
Okay.
I want to do legislation on this thing, on this thing, on this thing, and on this thing. Totally separate bills, different laws. Kyle's law represents a small facet of the overall pledge or the overall platform I've been proposing.
Yeah, that was one of the things that I was thinking about too when I was going through your tweets and all of your explanations on everything. Is that it's an ambitious project to get all of those changes made. If you're envisioning having those done, I guess, separately and over time, that might be a little bit more feasible to sort of tackle them one by one. Well, let's talk a little bit more, I guess, in depth about specifically what Kyle's law looks like, because I know that you've got some specifics, Andrew.
All right. So I had several. My core concern is that people can be dragged into a criminal trial when there's really zero prospect of them getting convicted. So there's no real legal merit, and they use the process of the trial itself as a punishment. So your life is destroyed forever because half or more of the country is convinced by a year or two of media coverage that you're some kind of racist murderer. You never come back from that. Because there's never an equivalent counter argument in the media. They only run with the narrative one way. So your life is destroyed, even if you're acquitted. And you spent, in the Zimmerman case, for example, their billables in that trial, 14, 15 months of investigation and trial, approached $2 million, which of course he didn't have. But like with Kyle, they were able to raise some of that money. And then the lawyers basically worked for free after a certain point. And he got acquitted, George Zimmerman, unanimously by a jury of every single criminal charge. And they brought a lot of charges against him by the time the jury was instructed. So he won that trial, right? But at what cost? He lost his marriage, his job, his life. I mean, now it's 10 years later. And I didn't know George Zimmerman personally at the time. I've come to know him personally since then. And I'm happy to say it appears like he's pulling his life back together and having something like a normal life now. But it's been a decade when that wasn't happening.
A long time.
It's horrible. Someone actually tried to shoot him in the head on his way to a doctor's appointment because they had bought into this media narrative of him as some kind of racist murderer. That person, by the way, was convicted of attempted murder, is likely spending the rest of their life in prison at this point. But that's what happens to you when they use the process as the punishment. So that was my primary concern. And there is a state, Washington State, has a law on the books around self-defense that basically says, all right, if it's a use of force trial and you raised a legal defense of self-defense, at the end of the trial, we have a special jury instruction, a special jury form. And we ask the jury, did the state disprove self-defense by at least a preponderance of the evidence? Now, to get a conviction, they have to disprove it beyond any reasonable doubt. They failed that, so you're getting an acquittal. But did they also fail to disprove it by even a mere preponderance, 51% of the evidence? And if the answer to that is yes, the state didn't even meet that threshold, under Washington law, the defendant is reimbursed for all his legal expenses by the state. Right. So we already have that law on the books in that one state. I don't see any reason why that shouldn't apply in every state. It's a perfectly reasonable standard. And then leverage that same standard to the prosecutor personally, because if he's only spending other people's money, if it's the state general fund that's going to reimburse the defendant and there's no skin in the game personally for the prosecutor, there's no incentive for him to care about any of that. There has to be some cost that he incurs on a personal level to deter prosecutors from bringing to trial cases where they're not even close to what would be required for an actual conviction.
Right. And so I have pulled up here that Washington statute so that anyone who's following along can read. So section 1 here is just I think that the basic self-defense language. And then section 2 here talks about exactly what Andrew is talking about. It says, when a person charged with a crime listed in subsection 1 of this section is found not guilty by reason of self-defense, the state of Washington shall reimburse the defendant for all reasonable costs, including loss of time, legal fees incurred, and other expenses involved in his or her defense. This reimbursement is not an independent cause of action. To award these reasonable costs, the trier of fact must find that the defendant's claim of self-defense was sustained by a preponderance of the evidence. If the trier of fact makes a determination of self-defense, the judge shall determine the amount of the award. So, but in this Washington law, it looks like it's just the state that would be paying
Correct.
reasonable fees, right? It wouldn't be the prosecutor individually.
Correct. Right.
So, but what you're proposing is actually even stronger than that, is so that the individual prosecutor actually has their skin in the game.
Right. So, we've given prosecutors essentially absolute immunity for any conduct they commit in their office. We don't hold prosecutors accountable for anything. I shouldn't say never, maybe once. I mean, there's Michael Nifong, once every 20 years or 30 years, we hold a prosecutor accountable. It's so rare that it may as well never happen, even in the most egregious cases of abuse. And I think we need some kind of standard by which we say, listen, you can't have immunity no matter what you do. There has to be some level of misconduct at which we pierce that prosecutorial immunity. And I'm suggesting this as that level. If you bring to trial someone who's facing the rest of their life in prison, if you convict them, and they might be convicted just on noise, there's always a risk of getting convicted, no matter how innocent you are. If you're going to subject someone to that risk and all the costs associated with it, and you don't even have a preponderance of the evidence when you do that, we ought to be privileged to pierce that prosecutorial immunity and hold you personally responsible.
Right. So, so then in this case, it sounds like the judge would determine how much of the fees and costs would be paid out by the state to the defendant. According to the law that you're proposing, would it be similar to that, or would there be certain, I don't know, or would it be different?
I mean, I'm ambivalent about exactly how it's structured. I just want the prosecutor to have some skin in the game. I mean, if we say the prosecutor has to, for example, the defendant's acquitted on self-defense, wasn't even 51% of the evidence against self-defense, he gets reimbursed for his legal expenses. If we say the prosecutor has to pay even 10% of that, that would be an effective deterrent, because we're talking 10% of $1 million or $2 million. So prosecutors don't get paid that much money, folks. If you're going to hit him for 100 grand, that's going to make him check himself. Make sure, hey, before I drag this person into court, I better know I have at least 51% of the evidence, because if I don't have that going in, I might not have it coming out. And if I don't have it coming out, I might be hit for 100 grand. So, and I don't think it's an unreasonable expectation in a case where, to get a conviction, you have to disprove self-defense beyond a reasonable doubt, that you go into that trial with at least 51% of the evidence when you need 90% to get a conviction.
Can I ask a quick question? Everybody's been discussing, laymen's have been saying Kyle's going to be rich, suing everybody for defamation. I know it's very difficult for a few reasons. I'm more than aware. I have a question with respect to what I mentioned with the city of Kenosha abdicating their duties.
Right.
Kyle could certainly charge to be reimbursed for his defense, because the entire position he was placed in was because of their abdication of their duties, right? Why he was called to be there, why he had to be there in the first place. Do you feel like he's going to have an option to sue them civilly, the city?
No, I would be very surprised. I mean, I don't do civil cases, so I can't speak from authority there. But generally, you can't sue a government for deciding not to do something. It doesn't work that way. So no, I would have no expectation there. If you wanted to be able to do that, you could make that possible, but you would have to pass a law that created a specific cause of action for a private citizen to bring that claim. So that could be another, another model statute that you propose to the legislature. If a state of emergency is declared, lots of rules can change, right? Mm-hmm. The rules for defense of property could change. So, for example, there's no reason that any state can't say, hey, in defense of even mere personal property, you can use deadly force. Texas does it. Any state could adopt that law if they wanted to, or they could adopt a law that says, listen, generally, we're not going to let you use deadly force in defense of mere personal property, absent a threat to life. But if a state of emergency is declared, looters will be shot. You could pass that law, and then the state has to really think about, do we want to declare a state of emergency here? Because if we do, the rules have changed for everybody.
Yeah, no, the federal government actually does have jurisdiction on that. I've discussed it with my father, and we discussed it for quite a bit. And if a local municipality, and they've already done this with the riots and with not calling in the National Guard, if a local municipality is abdicating their duties to the citizenry, the federal government has the ability to step in. So in that case, if
step in and do what? You mean attempt to provide security, like National Guard type stuff?
Well, I'm thinking more of a federal law that says if a state were to say our local police can't interfere with these riots, we're just going to let them run through the streets, would the federal government be able to use? Because that would obviously have to be something local. Again, it is a state issue. But I'm wondering if there's any sort of, where can we wiggle our way in where we could have the federal government standardize something? And I was wondering if that would be one particular area where they already have jurisdiction in situations like that.
You could, in theory, but you would need a specific cause of action. You would need a specific statute. So, for example, we have laws specific to police departments. If police departments engage in certain misconduct, use excessive force on a suspect, because they're doing it under the color of law, you can bring a federal, they call it a Section 1983 suit, and sue the department for that. Not just go after the officer. Who wants to go after the officer? They have no money anyway. You want to go where the deep pockets are. So, and this is all from the Civil War and Reconstruction and all that. There were police departments acting badly. So we created a specific federal cause of action so you could sue those police departments when their officers act badly. You could create a cause of action for almost anything you want, but it has to be created. It doesn't automatically exist.
Yeah, I think one potential issue with getting the federal government involved is essentially the law enforcement that would be called that would be federal would be some sort of National Guard or some sort of, United States military. And then you have the military acting on its own territory. And there are all kinds of.
I think he's talking after the fact. So
yeah, no,
seeking
I'm
some kind
talking
of-
about in the case of Kenosha, for instance, right?
Okay.
If you have a Democratic governor and a Democratic mayor, and for political reasons, they're saying you're not to interfere. So the police and the fire department do not go into this riot and save the lives of our citizens and protect their businesses from being burned down. One of the ideas I had said to my father is exactly what Andrew just said. Could you say at some sort of higher level that if anybody in this country makes that determination about about a local community, then you can use deadly force to protect property, or even not even highly defensible property, as they do in Texas. That was the exact same thing that I thought of what he had just said. So I'm not talking about the government sending in the military or anything like that. And by the way, to the chat, I'm no fan of the federal government. I'm a states' rights guy. I'm just saying if there's some way to standardize it. So some state that has defunct leftist governor and mayor, like we saw in Wisconsin, who essentially bowed the knee to the mob in this case and allowed these rioters to run rampant and didn't allow the local citizenry to be protected. In order to protect people in that situation, it has to be from a higher level. Otherwise, if you're leaving it to the local municipalities, those people are just SOL.
Yeah. So, yeah, I mean, yeah. So, but I guess what Andrew is saying is, for sure there would need to be a new law in the books in order to allow people to sue the either the state or the federal government.
Absent some specific cause of action, the courts don't like
sovereign immunity.
They don't like to step in over political matters, right? If there's not black letter law to support.
These are the laws that I'm talking. These are the laws I want to see. I'm saying, not could they do it now without a new law.
Sure.
Once you have that specific cause of action on the books, then you have something that's very concrete that the courts have to deal with. But absent that, the courts, if you bring them a political problem, they're going to toss it back into the political forum. They don't want to deal with that.
Yeah.
Absent some specific law on it.
Yeah. So this is an interesting question. Elena Stansby says, why do you need a new law? Why not enforce the one you already have, like the duty of the prosecution to be in the business of justice, not conviction?
Because that's not working.
Yeah.
That's not working. It used to work because the prosecutors used to hold themselves to that standard. But now the prosecutors are becoming increasingly politicized. These offices, these seats are being purchased effectively. Folks, in most prosecutors' races, we're talking a few $1,000s if anybody runs at all. I mean, usually there's one person who's been there 30 years, some old guy, well known in the legal community, he's been there forever. No one's really running against him. If anybody does, they each spend $2,000, $3,000. They get their friends to hold signs. I mean, these are very low. Most people have no idea who the prosecutor in their jurisdiction is. None. I mean, people don't care about these races unless you're doing inside baseball legal stuff. They just don't care. So if someone comes in with $100,000 or $200,000 or $500,000, they win that seat. I mean, they're the only name anyone will recognize in the ballot. So that they get elected to that position. And they're only coming in with that kind of money if they have a political agenda. Otherwise, those people don't exist. So they come in with a political agenda, they buy the seat, and now they're going to answer to their political masters, to people who paid for the cost of purchasing that seat, and they're going to make politically motivated prosecutorial decisions.
Yeah. So, let's see here. Yeah. I mean, all of that is those are all really great points. I guess if were there any other points that you wanted to talk about with respect to your Kyle's pledge?
I rely on you guys to tell me the best legal avenue to get these sorts of things implemented. But obviously, they all, again, require new laws. I'm not saying there's something we can do now based on the current system. The current system is broken, which is the premise of my post. The video that I put out, I'm essentially reaching out to both federal and local legislators to say this system does not work. The way it works right now, I can be involved in a clear self-defense case. I can hire Andrew to represent me, and they can go after me hard purely because it gets them likes on Twitter and helps them get elected next time around. And they're using my life as a pawn. I'm never going to see my children again if they're successful, and all they care about is a few shares and likes on Twitter and getting an extra 150 people to the ballot box. So they're using our lives as pawns, as they did with Kyle Rittenhouse and as they were doing in many other cases we've discussed. And that's the sort of thing we need to stop. Now, obviously, we can't do that now. We need new legislation. I think Kyle's law tackles a huge aspect of what we were talking about, which is abuse of the system, specifically in self-defense cases, and some recourse that defendants could have after the fact. Everything else is simply something that I need legislators to commit to so they can put together legislation. I actually had another state legislature, another state senator in California who would never get anything done in California, but actually DM'd me and asked me if I could share some of my thoughts on the things I was talking about because he had seen that video. So I'm relying on them to get it done. I don't know the answer on how to do it, but I do know what I want our leaders to pledge to, because these are things that drastically need to be fixed.
Right.
And I've listed them all: banning political prosecutions, empowering citizens in the case of Kenosha. And I'll come back to libel laws, because the defamation and jury pool tampering is rampant. You cannot get a fair trial. Derek Chauvin could not get a fair trial no matter where he was. It was simply impossible. Andrew said the same thing. When the prosecution is incapable of providing a fair trial, then they have a duty not to try that case. And
that's my position. I mean, I understood what the judge was saying in the Chauvin trial, because they kept asking for a change in venue for good reason. And he said, listen, there's no place in the state I can have this trial held that would be any different. You'd have the protesters and the rioters. No matter where in the state we hold this trial, it's going to be the same. And I think he's probably right about that. But the answer to that dilemma, to my mind, is not, well, give the guy an unfair trial anyway. The answer is, if you can't provide a fair and impartial trial to a criminal defendant, you're not privileged to try him. That has to be a fundamental obligation of government. You don't just get to say, well, it would be unfair everywhere, so we may as well have an unfair trial here. That's ridiculous, but that's the standard that currently applies.
Right. Here's an interesting question. Celtic Commando Gaming says, can't the residents of Kenosha already sue the city for failing to protect citizens, a la the Pot, Chaz, and Chop lawsuit against the city of Seattle? I actually wasn't aware that there was a lawsuit against the city of Seattle for it. But it seems to me that the residents of Kenosha probably cannot in this case. I don't know.
Which is one of the things I'd like to see put into future legislation. Exactly. They have no recourse now. Seattle father files lawsuit over son's death in the Chop Chat. So that was directly resulting in his death. Their dereliction of duty by not entering to prevent the shootout or to address the active shootout. That I can see there's a cause of action, but it's different than what Andrew was talking about. Right.
Because anytime you're talking about somebody's livelihood, it's a different matter or somebody's life rather than their home or their property or, their business, for example. So that would be a slight difference there. So I guess if you guys want, we can talk about sort of what sort of headway you guys have been able to make, or, what kind of conversations you've been having, and kind of where you see Kyle's pledge kind of moving forward.
Well, again, I'm not a politician, so I'm not looking to champion this myself. I think it's something that needs to be addressed. I thought it would be useful to put up a webpage kind of summarizing my thoughts on the matter that people could point to. If this legislator in Oklahoma wants to take the ball and run with it in Oklahoma, more power to him. I fully support that effort. If anybody would like to talk with me about maybe fleshing out the idea, that's fine. I can tell you that I'm not going to be traveling from state to state offering model legislation on this, because I'm busy being a small town lawyer. So I just wanted to build a kind of a community around it, get people interested, get people focused on a specific solution set for this particular problem, and hopefully build some momentum for people who are politicians to pick up the ball and run with it.
Right. So Andrew, I have linked in the description below your website on Kyle's Law. So anybody that is interested, that's watching, can go there and go and check it out. Otherwise, how else is the best way for people to get in contact with you about Kyle's Law?
Well, our webpage is simply lawofselfdefense.com/Kyle's Law. They can leave an email address there in a little field. We don't share emails with anybody. We're not asking for any money or anything like that. We're just trying to build community. So if there is a next step that we can point people to, we'll be able to reach back out to people and inform them of what that step is in an active way. That's really all I have going on at the moment. People need to keep in mind, I only put that webpage up like a week ago. So this has not been a months-long effort. This is just something that's happened in the very near term. So we'll see how it develops moving forward. I certainly hope it gets momentum. It should. I hope there are politicians out there who see political capital to be gained by advancing this effort. And I'm happy to support them in any way I possibly can.
Awesome. How about you, Jesse?
It was Oklahoma Senator. It was Nathan Dahm in Oklahoma who had proposed it about a couple of days after we had put up our content. So we're already reaching people. I mean, this is a local state senator, obviously. I've been in contact. Somebody else reached out to me on Twitter, and this is all very new. So I'll probably put something out where if I'm able to discuss the matter with them and share some ideas, because they essentially just said to me is, we understand you're not a lawyer, but your ideas are pretty much what it's a single pledge or a single list of what we're hearing from most of our constituents, most of our conservative constituents, especially who've reacted negatively to this case and the way Kyle Rittenhouse was treated. So I'll put something out further in the future. If people are interested and they want to find out more about how they could support any potential initiatives, just follow me on Twitter and stay tuned, and I'll put something out as soon as I have it. For now, I don't have anything more than that.
All right. So I don't know how you guys are on time. If you guys wanted to talk a little bit about the Chad Reed situation, I know that you guys are both dealing with issues at home with children and leaking houses. So, but I don't know.
I think I'm good on time. I would like to refresh my cup of coffee. Can I step away for just a moment
Absolutely.
and come right back? Okay.
Yeah, absolutely.
I don't want to leave you alone, but I have to go check, make sure the wife's okay with the kids. Can we start back up in 3 minutes? Read some super chats?
I could. Okay. Yeah. I mean, I've pretty much gone through the super chats for the most part up to now, but yeah, don't worry about it.
That's unacceptable. Everybody needs to give her some more super chats so we can read those. Get on it.
Thanks, Jesse. Thanks. Yeah, come on back. So I hope you guys have enjoyed this chat so far. I have found it very, very interesting because I think, on this channel, we talk almost exclusively about what the law is. So what was most interesting to me was that this is more of a conversation, not so much about what the law is, well, a little bit of what the law is, but more about what the law should be or what the law could be, according to some of the proposed changes. So I think that a lot of these changes are very interesting. And I think there could be a lot of really good things that could come out of it. Someone was asking in the chat about some potential downsides. So I think that thank you so much, MC, for the super chat. So I think that some of the downsides are as we get more and more expanded in some of these proposed changes, there's always a possibility that you can have some negative kind of side effects of any sort of law. But for example, with any time that we change the standard of defamation or libel laws, that obviously impacts speech. So there could be some way that impacts the First Amendment rights of any individual. And then at the same time, if you look at the liability imposed on cities or on states for failing to act in certain circumstances during an emergency, then obviously that increases the litigiousness overall of a society potentially in those kinds of environments. It could also limit the ways that the state decides to actually call a state of emergency at a time that they might need it. They might need to call a state of emergency. So there are always some potential drawbacks to any kind of new law. But I think that a lot of these ideas have a lot of really good potential here. Thanks guys for sending in super chats. Jesse stepped out for a few minutes too to check up on his kids, and so he recommended that people send in super chats to give me something to do while both of you guys were out. So where can I find the fund for the defendant who bought Rittenhouse the gun? What's that?
Dominic Black.
Yeah, Dominic Black. So there's a fund for that. Shoot, I know that Ricada has it. I will check back after the live stream. I will update the description with the link. I'll ask Ricada for it, and then I'll update it once I have it. Not sure if this has been brought up, but I realized that Making a Murderer was also in Wisconsin. That's an interesting point. Great conversation. Thanks all. Let's see.
So I see a comment here. Wonder what Andrew's daily carry is. So that would be my daily concealed carry pistol. I carry a gun for personal protection. I have my entire adult life. Currently, it's a SIG 320, but I'm planning to purchase myself a SIG 365 XL for Christmas. So that'll be my new carry.
Interesting. That sounds. Oh, so what's? I'm less of a gun expert, so explain to me, I guess, a little bit of the
well,
difference.
they're both 9mm pistols. The SIG 320 is a pretty sizable double stack magazine, like a Glock 17 size or Glock 19 size pistol. It's a fine gun. I like it a lot. I'm old, so my eyes don't work so great anymore. So I put dots on red dots on all my guns. But it's it's a little bigger than I would prefer. And the SIG has in the last couple of years come out with a new pistol, the 365, which is a smaller, still a 9mm. So
Do you want to see mine, or is that going to get you demonetized, Alita?
Oh, that might get me demonetized. I mean, realistically, I probably already am demonetized on this because we're talking about Kyle Rittenhouse. If we're talking
Andrew,
about literally almost anything,
that's one of my daily carries. I have I use a M&P Shield or the P365 depending on the day. But the 365 is incredible. 10 rounds in this tiny little format is incredible. I fell in love with that thing. So what were you saying that you just got?
I'm planning to get one, a 365 XL, maybe this afternoon. Yeah, so if I can find time to run to the gun store, I'll pick it up this afternoon. But awesome. Currently, it's I carry a SIG 320.
So I did a live stream the other night. I don't know if you would see. I'll send it to you so you can see the beginning. But I answered questions. So I was demoing with my old Colt A2, showing a forward assist and kind of explaining the relevance of the forward assist, because a lot of people were asking after Kyle's interview on Tucker. But if you wanted to see that, because that's obviously something that interests you, I'll send you a link. Sure. I was thinking in the case of the Reed thing, since virtually everybody is angry and emotional about this and nobody can agree on anything, I don't really want to talk about justified or not. We've all put our opinions out there. Most of us agree that we need to wait for more facts, but there are a few specific narratives that I thought I'm getting a lot. And when I try to dispel them, people say, well, you're not a lawyer. And it's frustrating because they're not necessarily questions that you need to be a lawyer to answer. You're just reading the plain text law and making a determination. So I was hoping I can give you guys a few of the things that I've heard the most, and maybe we can dispel those narratives that probably don't apply. I thought that would be a good approach. What do you guys think?
I'm in the hands of the host.
That's fine. That's fine with me. I'm happy. Lady? I'm happy to go through those. Yeah. Sounds good.
So the main things.
Actually, wait, before we do that, let's answer this question so I can remove it from the screen. Can the shooter in Texas be charged with reckless endangerment for the people filming? I haven't looked at reckless endangerment in Texas, but my guess would be they probably could be at least charged. But I don't know that he would be convicted since he had 2 shots. He was pretty accurate about it.
Well, the warning shot, I'm assuming they're talking about the warning shot. Yeah, I mean, that's sure, of course. I mean, it's very common for reckless endangerment to be charged in warning shot cases.
Yeah.
That's one question I do have for Andrew. By the way, as an aside,
I mean, people need to keep in mind when you're shooting someone, you're shooting a human being in self-defense. You're doing that to compel them to stop attacking you. You're using force on them to compel them to stop attacking you, and preferably you're doing it in a way that does not unnecessarily endanger innocent people in the vicinity. When you fire a warning shot, you're not doing any of those things. You're not compelling anyone to stop. You're just making a loud noise and sending a bullet into space, and you are endangering innocent people around. So there are circumstances where it can be justified to actually shoot someone and still not be justified just to fire a warning shot into the air.
So just so I can let you know really quick, a litigator I've met on Twitter has offered, he said he had reached out to you. Obviously your DMs are full. He wanted to offer his help in writing some potential starting point for legislation with respect to some of the things we discussed with Kyle's law. Maybe something you can get on the website that we can get eyes on from various legislators. So I'll put you in touch with him later, but I just got another DM from him.
That'd be great.
So one of the things that I keep hearing,
I mean, folks should know I'm not really, it looks like I'm an internet personality because I'm very kindly invited on all these shows and I'm happy to do it. It's a pleasure. But I work all day, so I'm not actually on the internet all day checking messages and stuff. I do it periodically. So if I'm not getting back to somebody, it's not because I'm deliberately ignoring anybody's message. It's just I just haven't checked that facet of the internets that day yet.
And so I'm hoping your legal expertise can help dispel this narrative that people keep throwing around, and I can clip this and just say, here are our resident experts explaining why this isn't relevant. For some reason, I'm not sure where this narrative was born, but some people have suggested that because the court had said that Reed is supposed to pick up his son at that location, that the owner of that property no longer has property rights and cannot trespass Reed from the property. Reed has full access to the property because he's supposed to pick up his son there, and it's a court order. I don't know who suggested that. It makes no sense, but I was hoping you can explain why that makes no sense so we can dispel that once and for all.
Well,
I guess I would just say I don't care about any of that. That to me, that's part of the noise that makes it so difficult to have rational discussions around this case, and it blends in very distinct areas of the law, like custody issues and property rights issues that have nothing to do with whether or not the shots that were fired were
Yes.
legally justified. And when people, I think people first need to decide what question are they seeking to answer. If they're seeking to answer a child custody question, more power to them. I don't know anything about that. I haven't practiced family law in more than 20 years and didn't do much of it then. So I just can't have any kind of authoritative opinion other than being a guy who's been divorced with children and had the usual kind of custody issues. Fortunately, nothing on this scale. But I'm familiar with the angst of that, of fearing you'll be separated from your child, of not having your custody rights respected by the other party. It's infuriating. But other than that personal experience, I wouldn't have any particular legal expertise to bring to that problem, except it's probably better if you can resolve those things without shooting people.
Oh, it is your expertise I was looking for. We lose audio?
What you're referring to is whether, I think that your point refers to whether or not he was trespassing. So because that would be right.
Trespassing is irrelevant in this case. My point was that Andrew could say, as far as the facts of self-defense, whether or not there was a reasonable expectation of the necessity of force, whether or not the guy had an agreement to pick up his son there is completely irrelevant. It means absolutely nothing to the case.
Yeah.
So when people keep bringing this up, it's frustrating. Like, it does not matter. Trespassing is irrelevant. He could have been trespassing. He could have not been trespassing. He wasn't shot for trespassing. It has nothing to do with the facts of the case. And these narratives keep getting brought up. And when I try to dispel them, people are trying to tell me I'm not a lawyer, and they do have to do with the self-defense argument, but they clearly do not. Hence why I wanted your expertise to sort of dispel that so people can maybe let go of those irrelevant facts that just cloud the discussion. It's very frustrating.
I mean, use of force law is really very straightforward. The question is, at the moment the shots were fired, was Kyle Carruth, I guess is his name, was Kyle facing a reasonably perceived imminent threat of deadly force harm from Chad Reed? If he was, that's a justified use of deadly force in self-defense. If he wasn't, it was just a murder or a manslaughter. Right. It wasn't self-defense. So you might disagree on the assessment of the facts, but that is the legal question that needs to be answered. And when I look at the video, I don't see Chad Reed 10 feet away, unarmed, standing still, presenting in that moment. Forget what he was doing earlier. You don't get to shoot people for naughty behavior they were doing earlier that they're not doing at the time you shoot them. Okay. Were they both a-holes? Probably. Were they both acting like morons? Certainly. But you don't get to shoot people for that. So if you're going to shoot someone dead, it has to be because they were presenting as an imminent deadly force threat in the moment you decide to shoot them.
Yeah, and I think one way that's maybe helpful for people that are sort of seeing, because I admit that when I was first looking at this incident, I was definitely getting a little bit lost, as you know, couldn't where what's the phrase where you can't quite see the forest for the trees, right? Because you get so lost in the details of this whole scene because there are so many details in it. But I think that one way that's sort of helpful to sort of think about it, maybe, and correct me if I'm wrong on this, Andrew, but one way that might be helpful is if you sort of bifurcate it to the moment of the shooting and then the things that happened beforehand, because you kind of have to analyze the moment of impact of the shooting, of the trigger firing. You know, was there a justifiable imminent threat, or was there a reasonable belief that there was an imminent threat?
And the prior conduct can inform your assessment of the reasonable threat in the moment. So, for example, there was this verbalized threat to take the gun and use it against him, and an actual effort to attempt to grab the gun, by all appearances. And certainly, if if at the moment the shots were fired, Chad Reed had even shifted his body weight forward as if he was going to close distance, I would call that a good shoot every day of the week. He'd already threatened to take the gun. He'd attempted to take the gun. Now he's closing distance, presumably to take the gun. That's a reasonable inference from the prior experience. My hesitation with calling this justified is I just don't see that closing of the distance. And absent that, you're simply shooting a man who's 10 feet away, standing still, who himself is unarmed. And I don't see that as an imminent threat.
If you haven't seen the defense's claim, if you look at just a few frames of the video, after Carruth is released, before he fires, when Reed is standing on the porch, his left leg moves slightly. It's a twitch. It's very minor, but it does. And the defense is saying that was Carruth's perception, was that he's about to start lunging towards me. It's a hard argument to make. It's barely a twitch. But
right. I don't find it compelling. But obviously, reasonable
I didn't know if you
people
had
can
seen
differ.
it. I just didn't know if you had seen
I
it.
heard the lawyer's claim. You know, I mean, I need more evidence than
he's moving his left leg
claim.
like an inch and a half. It's not a huge motion. I understand what you're saying. I just
it's very subtle, but clear to my mind. If Chad, for example, if he had clearly stepped off the porch, closing distance, it would have been a good shoot every day of the week, twice on Sunday. I just don't see that in the video.
Right. So, so to sort of go back to your initial question, Jesse, about the whether he had a right to be there, that would be sort of that if we were to bifurcate the scene into the moment of the shooting and everything leading up to that, that would go into the everything leading up to that. And so that would kind of speak to whether or not he was trespassing, and that goes to, defensive property and all of those kinds of sort of things. But in this instant, I guess, so something that is sometimes difficult, especially with this kind of a scene, is that you kind of have to almost work backwards, which is not the way that the scene played out. Which so most, and that was kind of the mistake that I think I was making when I was first looking at this, was that I was looking at this, going through what do these individuals see starting from the beginning to the end, but you kind of have to first start from the end and then go backwards and then maybe look at it from the beginning again. But
that's correct. Yep.
Yeah.
Here's a big one, because this is the one that set off my followers. People are so emotional and there's so many biases involved. Again, I'll send you the video where I discuss those types of biases that I personally am experiencing and what I feel other people might be. But I'll say something and I will be attacked for saying things I didn't say, didn't think, didn't argue, and don't believe within the next 5 minutes. And it's people are just so emotional. They have
welcome to the club.
Yeah, exactly. Which is why I said to Andrew, we'll talk about it on a stream at some point, because he and I are horrible on Twitter. We keep going back and forth and just misunderstanding everything the other person is saying.
And that's the thing about tweeting conversations anyway, right? Like I had like 2 tweets on this, or maybe a handful of them, and then I walk away for an hour or two, and I find I have like 50 notifications. I was like, I can't possibly respond to all of these. So I was like, I'll talk at some point on YouTube about this.
and especially when multiple parties are involved in any particular tweet, then nobody knows who's talking to whom about what, or it just it just becomes a hot mess. So I'm always happy to discuss these issues, but it's much easier to do it in a setting like this than on Twitter.
You guys will obviously, Andrew initially, when he saw my post, agreed with it wholeheartedly, and then we sort of got lost in replies to replies. But what I found uncomfortable was during the Rittenhouse case, people on the left said simply being in Kenosha with a rifle is so inflammatory because guns are so horrible that even standing there legally holding a gun is provocation enough. Well, it's not legal provocation, because the statute specifically says, statutorily, provocation in a legal perspective to preclude your use of an affirmative defense needs to be derived from some illegal act, right? Physical assault with a weapon, pointing it at somebody, what have you. In this case, those same people who are defending Kyle against that accusation are saying that Carruth going to get the gun, even though it elevated the temperature, even though it provoked the situation more, they're claiming that, much like Binger claimed with Kyle, is legal provocation. And once he gets the gun, it legally provokes Reed, and he's no longer allowed to claim self-defense. He legally got the gun, a gun he's legally allowed to have on his porch where he's legally allowed to be. He didn't aim it and didn't threaten anybody with it. Under Texas law, he's standing there legally and not breaking any law. It cannot be legal provocation. He did provoke the situation, colloquially, but it's not legal provocation precluding him from using a self-defense defense.
I mean,
So
the
that's all I said.
provocation issue only matters if you believe that the shooting was otherwise lawful self-defense, but you're going to attack that claim of self-defense on the grounds of provocation, that he'd
Yes,
lost the privilege
some
of
people
self-defense.
responded
But I don't believe
saying-
the shooting itself was lawful, so I don't need to be concerned about. I'm willing to give Carruth the benefit of the doubt on everything that happens prior to his firing the shots. I'm willing to, for argument's sake, let's concede the gun was lawful. He was entitled to have it. He wasn't doing anything illegal with whatever. Even
was
say
my
the warning
point,
shot
yeah.
was good. If you want to, I don't care. That's fine. I'm happy to concede all that, because at the moment the shots were fired, regardless of all that, I don't see an imminent deadly force threat being presented by Chad Reed. So
that's what upset my followers. I said the exact verbatim thing. Everything up until him shooting. Let's agree. It was a bad shoot. It's murder. Fine. We're in total agreement. We're not even discussing if it was justified. We both 100% agree. To me and my followers, I'm speaking. We 100% agree. All I'm saying is everything up to that point, he didn't break any laws. And if you support one's right under protection of your property or their 2A rights, you should support his behavior up until that point, even if it might have been a bit irresponsible. It's certainly legal. And
the trouble
people are
is
telling
there's
you it was illegal.
there's lots
I
of
would
factual.
caution that though. I would caution that though, because I was someone that was looking at provocation as an element of this whole scene, and so I was doing some case law research on this, and so in Texas, other facts surrounding this scene could change that analysis. So on the facts that we have, in these particular videos, you know, because there's two of them. You're probably right that there probably is no provocation based on what we do see. However, there is potentially more information in this particular case because we know that they know each other, and they know each other to a certain familiar extent because they're familiar with each other's family and with children and all that kind of stuff. So I have seen case law that, you know, in Texas, there was a case, I can't remember exactly which one it was, but there was one where there was evidence that the day before somebody actually did claim self-defense in a particular case. The day before, they talked about wanting to shoot that specific individual, and so that evidence came in and actually was used to show that it was provocation because of the fact that he was using a particular move that would otherwise be justified. But that in this particular case, because of that prior statement, the courts found that and said, yeah, that probably was kind of just that goes to show that this was an excuse essentially by this individual to provoke the person to attack them. So that's the one asterisk that I would put on that, is that under the facts that we see here, probably no provocation based on the fact that, you know, he was on his property, you know, the entire time that he had the gun. He didn't step off his porch when he had the gun. You know, Chad Reed came up onto the porch to him, and then they had the scuffle. So those are important points.
You want to pull up my screen and I can show the legal justification for my argument if you're interested. This is very simple. This is all there is. It's a single paragraph in Texas law. The threat of force is justified when the use of force is justified, because you can't threaten force or use force unless deadly force is perceived. So for the justification, as I was telling Andrew, is the same in Texas. You can't threaten deadly force against somebody unless you perceive immediate deadly force. But the more important part is here. The production of a weapon, as long as the actor's purpose is only creating an apprehension that he will use it if necessary, does not constitute the use of deadly force. So what that means is, if you walk out with a gun and you're holding it and you say, get off my property or I'm going to shoot you, that's illegal. That's the use. That's a threat of deadly force. You can't do that. That's provocation. If you walk out and
you believe that's the reason,
Right.
If you believe that's the reason, you may not believe that's the reason.
He walked out holding it and didn't say anything. He was simply standing there, right? So without a verbal command,
if we had a record of a conversation the prior day where Kyle Carruth tells somebody, that's recorded, says, I'm going to get this guy to my house, and when he gets upset because we don't have his kid here, I'm going to escalate things by bringing my gun out and having an excuse to kill him.
Do we have that recording now?
No, I'm saying that this only applies if you assume the facts to be present, but the facts don't need to be present.
I'm assuming the facts we currently have. So under the fact we currently have, standing there with a gun you're legally allowed to have on your own property is 100% legal and cannot be provocation unless a recording exists, unless you aim it, unless you say, get off or I'll shoot you. Are you in agreement?
Unfortunately, what I fear people do is they read this statute and they presume that what it means is you can always produce a weapon and it's always going to be lawful, and that's not true. It depends
on
on
this case.
I would say on the facts that we have right now.
Correct.
Yes, it appears
you.
that there's no provocation, but other facts can come in if they were discovered. You know, if they let's say they did bring charges and they had other witnesses come onto the stand and they talked about, you know, other details that changes the context of this incident. That could happen. That could show that there was in fact provocation by Kyle Carruth. So
again,
that's what I'm saying.
All that only matters if you would otherwise believe that the shooting itself was lawful.
That's true.
If you conclude the shooting was not lawful, you don't need to go to provocation. Provocation becomes irrelevant. It was an unlawful shooting. Provocation is only relevant if you believe the shooting was otherwise lawful, except that it was an act of provocation and therefore self-defense is lost.
The point of my comment, again, wasn't about whether or not it was or wasn't lawful. I was solely saying to the 2A community who was saying walking outside with a gun was provocation, like with Kyle Rittenhouse when Binger said standing there with a gun is provocation. You're using the same argument in this case that the left used against Kyle Rittenhouse, so you should reconsider that one specific argument, even if he's guilty as sin, whatever. That one argument.
I just think it's an unproductive use of time. I mean, one of the things we have to do as lawyers is take very complex fact patterns and cases and distill them down to the issues that are controlling in that case to get to a legal outcome. There's always going to be lots of hypothetical scenarios and incidental facts and what of this and what of that, but unless it changes the fundamental legal conclusion, it's just chatter. And I don't have time for chatter. I can't bill for chatter. I just don't think it's, I mean, if we're going to sit around and have a few drinks at a bar and talk about the case, that's all fun. That's all great. That would be a great forum to do that. And I guess maybe Twitter is the place to do that too these days. But it's not something I can do. I don't have time for that.
Got it.
Yeah. Well, the other thing is, which you might be interested to hear, because we had briefly talked about if a bench trial would be better because a jury would probably, be hard to convince in this case. But I've actually since heard from a couple people, a couple followers who actually live in Lubbock, and they both universally agree there's no chance that community is going to convict him. Every member of that community that they've shown it to has said he told them to get off the property. Sorry, that's it. So it depends.
I don't think what people say would be likely to happen is very meaningful until they've heard the arguments.
Well, I know. I'm just saying that's what I've heard from people in the community. That's all.
Okay. But by the way, it may be true. I don't predict verdicts. I don't predict what a jury is going to do. The juries are dangerous and unpredictable creatures. They can make a verdict for any reason they want or no reason at all, rational or irrational. They're not required to explain their reasoning to anybody. So that's the reason I don't predict verdicts. All I do is legal analysis on the legal merits. Take the law, apply it to the facts as we know them. This is what the outcome ought to be if it was based only on the legal merits. Then you feed that into a jury, and who knows what's going to come out.
Right. That's true, and you'll find that that line of thinking is very common with most litigators, if not all, because it's you can convince a judge through your argument, through legal reasoning, but a lot of times, and because a judge is generally speaking very much used to going through those kinds of arguments, but a jury, there's all kinds of things that can go wrong for from a lawyer's perspective, because you can do the best that you can to frame an argument. But sometimes, as kind of the premise for going through this list of stuff, right, Jesse, is the fact that people are very emotional about this stuff, because people are very emotional beings. The same thing is definitely true of the individuals that comprise of a jury. So, yeah,
I mean, people need to separate the kind of the legal merits of the case from the verdict you get. I mean, ideally that would be a perfect relationship, but we don't live in that world. There's noise in between those two things. So you hope to build the most compelling, legally meritorious argument you can to feed to a jury to help induce them to come to what you think is the right verdict. But whether they do or not they come back with not guilty. It doesn't mean there wasn't legal merit to the underlying argument. They just, for whatever reason, may have decided, oh, we don't like that guy. We think in Texas the law should be you can just shoot someone standing on your porch. Who knows why they come down with the verdict? But that's not what the law actually says.
Yeah, as a legal purist, you would obviously, that's one of the biases that I'm experiencing in this, which just sort of seems, it just feels at a gut level. I know it's not legally justifiable, obviously, but one of the biases that I'm experiencing personally is looking at the situation. While I obviously don't see a dramatic threat, and I'm not sold either way, so people think I'm defending him. I'm not. People have had a difficulty separating the moral and ethical from the legal, so making the argument it may legally be justified is not me saying I think he did the right thing. Obviously, morally and ethically, I think it was the wrong thing to do. But one of the issues where I'm experiencing some bias is it feels kind of crazy that right now you could present an immediate, imminent, deadly threat to me, and I'm justified in shooting you. And if I hesitate for a half a second before actually pulling the trigger, I go to prison for the rest of my life. Your behavior dictated such a threat to me that I'm justified in taking your life. But if my trigger finger twitches for a split second and I miss a half a second of time, I go to prison for the rest of my life. That feels unfair.
Fights are dynamic events. They're very fluid. They change quickly. Folks, we all drive cars. We all make decisions in fractions of a second every time we're driving a car. We're all making tenth of a second decisions driving. So it's not beyond the realm of normal human beings to be making decisions in that kind of time frame. If the circumstances of the fight change, your legal options change. I mean, if the person drops their gun, steps back, a million things can happen that change what you're privileged to do. You don't get to simply say, I was privileged to shoot him dead a minute ago, or half a minute ago, or 10 seconds ago. Therefore, I'm automatically privileged to shoot him now. If the circumstances have changed, you may no longer have that privilege.
That's a fair point. And I think that sort of analogy to driving is a very good one. I hadn't thought of that, but that's something that obviously most people over the age of 16 have done at some point in their lives. And so, being able to distinguish from one moment to another, the wisdom of a particular action is something that we can all sort of understand in that respect.
We've all been behind a car that suddenly put its brakes on, right? And had to respond instantly to that signal that circumstances had changed. Now we're closing rapidly on that other vehicle. If we don't want to crash into it, we have to change our conduct. We have to make a decision. And that's within 0.2 of a second, probably.
Well, CNN recently told us that cars drive themselves into crowds. So,
yeah.
We all know better than to trust CNN on their factual assertions.
Cars have been known to just randomly drive into crowds on their own without any.
Here's one question, and I know Andrew, I think this sort of what you were saying earlier, you may not want to delve too deeply into this because it's sort of getting into some of these details that you might feel is a little bit superfluous. But so Mikey asks, what's the case for Chad is acting in self-defense when Kyle fired a warning shot, a deadly show of force?
Yeah, I mean, you can make that argument, right? He believed he was going to be shot, so he's trying to defend himself against the gun. But so what? I mean, that's not actually what happened, right? He didn't actually defend himself in that situation. And you don't get to shoot someone because they shoved you off your porch. I mean, I see a lot of this stuff where, well, basically they're justifying the shooting because of the custody issue, or he got pushed off his porch, or Chad jumped up on the porch, or none of those are legal justifications for shooting somebody dead. The legal justification has to be that they present as an imminent deadly force threat in the moment that you shoot them. This other stuff is just noise. It may inform that decision, but it really only matters if you believe the shooting itself was, in essence, lawful, and you're looking for ways to attack that otherwise lawful use of force. And I don't see the use of force here being lawful because of the positions of the people, the distance involved, the lack of Chad Reed having any kind of means to project force at Kyle over that distance in the moment the shots were fired.
Right.
Now, people may believe, hey, I should be privileged to shoot someone if they shove me off my porch. That's fine. You can have that feeling if you want. You can even propose that legislation, maybe get that passed into law, and maybe that would then be Texas law. But that's not what the law says you can do now.
Yeah, that's a very good distinction to make. For a lot of people, is that there is a difference from, the first hour that we were talking about. I was sort of talking about this when both of you left, that, the first hour we were talking about what some proposed changes to the law, like what the law should be or what the law could be. But typically what we're talking about in this channel is what the law is. And so that's sort of representative of sort of the after an hour in on this particular live stream. That's really what we're talking about then is we've sort of shifted the mindset going from what the law should be to what the law is. So Jesse,
there's also a major area of misunderstanding here. I see a lot of big capital letters in the comments here. People saying that is what the law in Texas says. No, folks, that's not what it says. You're misreading the law. There's law in Texas about defense of. If you like, it's okay with me.
It's right here.
Texas has a law that creates a legal presumption that you had a reasonable fear of imminent deadly force harm if you're dealing with a forcible, unlawful intruder into highly defensible property. In this context, meaning your dwelling, and the front porch would count as part of that property for purposes of this legal presumption. But folks, it's a legal presumption. It's not an absolute 007 license to kill. It's presumed that you're facing that threat, but that presumption can be rebutted by other evidence. And the evidence here is that the person who was shot was unarmed, standing still on a porch 10 feet away, not presenting in the moment an imminent threat of deadly force harm. That rebuts that presumption. You're not automatically privileged to shoot that guy.
So explaining what what it says here, this is what people are referring to where it says you can use force if A or B, right? But A1 statute or the statutory requirement for A2 needs to be met for these to be met, right? That means A2 is referring to imminent deadly force being perceived. So if you don't justifiably perceive imminent deadly force, then this part doesn't matter. It doesn't matter if you're thrown off your porch. It doesn't matter
by the way,
if somebody does something.
I really consider these legal presumption of reasonableness. I think they're good laws. I'm a fan of them. I would advocate for them, but they don't really matter. I mean, if you've shot someone and you're claiming self-defense, it's already legally presumed that you had a reasonable fear of imminent deadly force harm because the state has to disprove your claim of self-defense beyond a reasonable doubt. You're presumed innocent. You're presumed to have a valid defense until the state disproves it beyond a reasonable doubt. And that's true on the street, on your porch, in your house. All that this legal presumption language does is kind of formalize it in the context of your home.
Right. And really all that's referring to is the burden of proof. So typically in any kind of a criminal case, the prosecution bears the burden of proof for most of these things. I mean, when it comes to self-defense, that's typically an affirmative defense that gets brought on by the defense. So that means an affirmative defense usually means that the defendant then has a burden to show that part, to show that they were actually acting in self-defense. So a statute provision like this one is what we would call a burden shifting provision. So that would basically mean that it shifts the burden back over to the prosecution to show that essentially they didn't have or that the defendant wasn't acting in self-defense.
Right. I mean, the only burden on the defense is what we would call the burden of production, which is to provide some prima facie evidence in support of self-defense, which really only means more than zero evidence. So if you show a hair of evidence that's consistent with self-defense, you've raised the legal defense of self-defense. Now the state has the burden of disproving it beyond a reasonable doubt. When we say it's legally presumed that you acted in self-defense, well, you already have that presumption because the state has to disprove it beyond a reasonable doubt already. So it doesn't really do much, except that it's useful as a jury instruction to read to the jury to kind of reinforce where these burdens are. And that's always a good thing to do.
Right, right. So there was one last, I guess, super chat question earlier that I didn't get to because it was much earlier on in the discussion. Somebody wanted to know, Ken Davis was his name. He had a super chat. I wanted to know how to retreat when someone invades your home. It's not exactly relevant specifically to this incident since that didn't actually happen. But since we have Andrew here, let's say there was a state that somebody lived in a place where they did have to retreat within their home. What would that look like, I guess?
Well, it could look like Massachusetts. So
lock yourself in a panic.
If you're in your home and your spouse attacks you and you want to defend yourself and you have a safe avenue of retreat, you're required to take advantage of that safe avenue of retreat before you can defend yourself and justify that use of force in self-defense. So in that context, even though you're in your castle, and Massachusetts has a castle doctrine, it says you don't have to retreat from a genuine intruder into your home. But if it's a co-dweller They say, well, you've reacquired that duty to retreat. So it's very common in spousal abuse situations. Violence occurs, and then one party wants to claim self-defense, but they could have walked out the back door and they didn't, and therefore they don't qualify for self-defense.
Right. So, and then I guess one other question that we got a super chat from Roy Muralunos earlier. He wanted to know if there is a donation page for promoting Kyle's Law. I think earlier you said that there wasn't, but do you have any plans on setting anything like that up?
Probably not. If you're asking me, probably not. I don't want to be collecting money for this. So somebody should, I guess, eventually. But I would prefer that would be whoever is going to be the genuine champion behind this, driving this forward. And that's not me. That would have to be, some legislative organization, some model statute organization. And certainly if somebody sets that up and they appear to be legitimate, I would certainly contribute myself. But I personally will not be collecting any money from anybody for Kyle's Law.
Yeah, I think what I'm doing is people have reached out to me to get my thoughts on it because they liked my thread about it. I have no expertise in that matter, so I'm waiting until if there's some group or some person who specializes in pushing for legislation and pushing for public policy. They want to take in a run with it and ask my advice based on what I think conservatives want to look for based on my threads, and Andrew's expertise based on his self-defense law expertise will both contribute to them, but that would eventually be who you want to contribute to, not him or I, or obviously. So stay tuned. Like I said, if that gets to that point, if I'm in contact with somebody who can help out and get some public policy pushed through, I'll post as much as I possibly can about it.
I mean, I will say in passing, once every couple of years, we do what we call our law self-defense advanced course. It's a full day course, 8 hours, 9 hours sometimes, depending on how much Q&A we have. It's basically like a law school seminar in self-defense law. We teach this as CLE for attorneys too, but we teach it in a plain English fashion, so it's appropriate for anybody. And we do have one of those classes coming up January 8th. If people see the URL in my little photo here, lawofselfdefense.com/advanced. We're doing one January 8th. It'll probably be another couple of years before we do another one after that. So if anybody would like, in one day to gain genuine expertise on self-defense law, that would be the opportunity to do it in one sitting. It's live. I teach it live, just like you're watching this live now, assuming you are watching it live. But we teach it over Zoom. It's all day on a Saturday. And we stay as long as we need to stay on the Zoom to answer everybody's questions. So to make sure all that gets covered, that would be, frankly, probably the single best opportunity to gain real expertise in the subject matter in one sitting.
I'll be there.
Any lawyers that want to join, they would get CLE credit for it as well?
Well, see, unfortunately, I've done an enormous CLE work, at least 35 states. We've been accredited to teach CLE, but you have to get the course accredited each time you teach it. And when it's online content, different states add different rules to make sure the lawyer's actually watching it and doesn't just turn his computer on and walk away. So you have to embed code numbers, and it just gets too complicated. So we don't affirmatively get this accredited for CLE in all 50 states beforehand. But a lot of jurisdictions will allow lawyers to self-report education for CLA. And for that purpose, we do provide lawyers who ask for it with a syllabus of the course so they can use it for documentary purposes. Got it.
Okay. Well, other than that, Jesse, did you have any other points on that list that you wanted to talk about?
Oh, there was one other thing I wanted to touch on. A lot of people are asking about Texas statute, Penal Code 9.42, which is the deadly force in defense of personal property statute. Texas is the only state that has any provision for the use of deadly force in defense of mere personal property. If people want to read the statute, and I would urge them to do that, you can just go to lawofselfdefense.com/942 for the number of the statute. It'll pull it right up. Folks, there are a lot of conditions in that statute, every single one of which must be met. There's a lot of references to reasonableness and similar ambiguous terms. And it doesn't matter what your belief of what was reasonable was. It matters what other people's perception of what was reasonable was. The cops, the prosecutor, the judge, the jury. And if their view of what was reasonable differs from yours, you pay the price. So I would caution against putting too much trust in this particular statute. Also, you have to ask yourself, were these conditions being met at the time the shots were fired? A lot of people are pointing to this fight, the struggle over the gun, the momentary struggle, saying, well, that's a burglary on his property. And maybe that's all true. Let's assume that's conceded. There was no burglary happening when he shot him. which is when it would need to be happening in order for this shooting to be justified on this basis.
All right.
Yeah, that's
So-
actually the last point. Is I've been saying that a lot to cut through all the noise. I've been pointing people to what Andrew's been saying too, but I've actually, since I put out my analysis where I kind of gone through all this with my views on it, but I've been saying since the start, the entire thing, working backwards, as you've said, comes down to that one freeze frame of when the shot occurred and the preceding 589 milliseconds from when he was thrown from the porch. If he can convince a jury that in that half a second he couldn't change his actions and had to shoot and he still felt there was a deadly threat, that's it. That one brief half a second is all that matters, and you can work back from there. But if you cannot say in that one half a second that he felt that that deadly force was justifiable, then case closed. That's it. All the other details, custody or trespassing, are irrelevant. And that's what I've been trying to repeat, that people don't want to let go of. But I'm happy to have you guys to kind of back me on that, because cutting through that noise is difficult, and it just distracts every conversation about this case. You can't even get to that point because you're too busy talking about these random various details that are irrelevant.
Right. And it's normal for people to do that, by the way. It's not bad. People aren't bad for doing that. That's how people in normal conversation talk about these things. But that's why lawyers are trained to look at these things in a more disciplined way.
And even lawyers can get it wrong too.
Oh, for sure. Hey, every trial.
I say that as you know, myself, my initial approach for this was definitely not the way that Andrew did. And that's why I like to repeat that even for lawyers, they call it the practice of law for a reason. Like you're out there practicing every single day, that you are working, that you are analyzing the law. And so with that, you keep learning, and hopefully you don't lose what you've already learned before. And so you keep adding to your knowledge and to your practice. So lawyers can absolutely get it wrong, and we can always learn how to approach things in a different way. But I think that what Andrew was saying is absolutely correct, that, taking that approach in a very rigorous sort of way, and also trying to sort of separate yourself from your emotions is also a good thing, as much as possible. So anything else you guys wanted to add to this?
That's it for now. I have to get going anyway. I'm needed upstairs, I think.
All righty. And I know that Nick or Kate is about to have Nathan DeBruin on his channel in about 10 or 15 minutes. So I think there's going to be a lot of interest in that one. So I will
ask, I love Nate because of his trollery of Krause and Binger, which is why I'm a huge fan of his. I don't know if you had a chance to see, I've been trolling Binger of late. I've been getting emails, all sorts of things. I don't know if you guys had seen this, so I just wanted to tell you. He cited the Wisconsin legal procedure rules, how he couldn't discuss the case immediately after. And then he told the Chicago Tribune that while there was a verdict of not guilty, that doesn't mean Kyle Rittenhouse is innocent. And of course, there's potential civil litigation upcoming. And I had to troll him with that. Apparently, he's quite upset, and he responded to the Kenosha Eye in a very, very childish manner. And I posted that email as well. So I'm not done with Binger. That guy's on my list. I'm going to continue trolling him as much as I can, because I don't appreciate his behavior and what happened with that case. So keep an eye on that, and definitely see what Nate has to say with Nick today. I'm excited to hear that.
Hey, next up is Kim Potter, right? Kim Taser Potter. That trial starts tomorrow.
Yeah,
for those who are interested, I'll be covering that trial live, just like I did for Rittenhouse and Arbery throughout the day over at Legal Insurrection. That's not my website. That's they kindly invite me to write there from time to time covering these cases, and they sponsor my work doing that. So it wouldn't be financially possible for me to do it but for their sponsorship. So I'll be live tweeting and live streaming that trial starting tomorrow morning over at legalinsurrection.com for those who are interested.
Excellent. And I will link in the description below to that as soon as we walk out of here. And then other than that, there's of course the Ghislaine Maxwell trial starting today. I think Justice Smollett is also starting today. There's a lot going on, and we're going to try to at least touch on all of them at some point, because I obviously with the inability to live stream straight from the courtroom, it makes things a little bit more difficult than what we were able to do with Kyle Rittenhouse. But there's a lot going on. So absolutely. So everybody go and be sure to check out Jesse, Darth Crypto on Twitter and on YouTube. Same with Andrew Branca over at Law of Self-Defense. Website, Twitter, and YouTube. Anywhere else that you guys want to direct people to before we...
I do have a new locals channel. We're experimenting with that because I see Viva Barnes is on there, and I'm not very technically savvy, folks, so I apologize beforehand for all that. But we are beginning to post some content up there. It would just be, I guess, lawofselfdefense.locals.com, I think is how that syntax works. Or just our webpage, lawofselfdefense.com. We have a lot of blog content there. I will say that most of our normal course of business is our content is limited to our members. We have a membership service. It's less than $10 a month to be a member. The only time we really have open access content is when we're covering one of these high profile trials. So for those of you new to me and new to Law of Self-Defense who see all this free stuff going out, I'm glad you're there. Enjoy it. But once the trials are over, I would encourage you to, if you like the content, to become a member.
Absolutely. And and then also the Dominic Black fundraiser, people sent me the link, so that's already in the description. So if you guys are interested in that, be sure to check that out.
Yeah, I've posted a lot about Dominic Black. Everybody just keep an eye on him. It's really unfair what's going on there. Binger's still going after him, even though the exact same charge is subject to the same exemption that had it dropped against Kyle Rittenhouse.
Same
Andrew
judge
was writing about this after our discussion.
The same judge who made the ruling.
It's the same judge, same prosecutor.
Yeah.
So, and the worst part is Dominic Black's attorney hasn't refiled a motion to dismiss in which he could have cited the judge himself in his dismissal, cited the same prosecutor in his concession that he doesn't want to protest, and cited Corey's argument on why it should be dismissed. All he had to do was refile that day. Nick Ricchetta said the same thing. He should have refiled that motion immediately, and he didn't. I don't know why. So just keep thinking about Nick and about Dominic. And if you get his fundraiser info up, I'd encourage everybody to contribute whatever you can.
Absolutely. So otherwise, if you guys enjoyed this, be sure to like the video if you haven't already. Subscribe to the channel for more content like this. And otherwise, you can find me on all of the other social media platforms. Links are in the description below. So with that, we'll sign off. Thanks, everybody. See you in the next one.